Over the past 75 years, more than 10,000 chemicals have entered our food supply, but the EU allows just 300 additives. At Thrive Market, we prioritize quality, banning over 1,000 ingredients found in conventional grocery stores. Our Healthy Swap scanner helps you find better versions of your pantry essentials without the junk, dyes, or fillers, and everything is delivered right to your doorstep. So shop at a grocery store that actually cares about your health at thrivemarket.com/get-started for 30% off your first order and a free $60 gift.
Welcome to Think About It with your host, Jaden Miller.
Good day, and thank you for joining me on Think About It with Jaden Miller. It's good to be back on the podcast waves with you all. Please check out my website at www.jadenmiller.com, JAYDENMILLER.com. Please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. You can find me on Spotify, Apple Podcasts, Spreaker, Google Podcasts, Castbox, iHeartRadio, Audrey, Podvine Podcast, and Amazon as well. So I hope everyone is doing well. There has been a lot going on with the United States Supreme Court as of late. And so what I'd like to do is to provide some perspective. All right. So we have the conservatives that are really, really happy with this Supreme Court decision reversing Roe versus Wade. And then you have the liberals that are really upset because they feel now that the reversal of Roe versus Wade sets women back 50 years, if not more, and that this opens up the opportunity for the United States Supreme Court to reverse some other major rulings from the past. And so what comes into question then is this issue of precedent and stare decisis. And I will explain what those things are in a minute. But what we first need to do is we need to go back and understand why the Supreme Court ruled the way that it did. I think that's extremely important to understand. All right. What's also important to understand is that in this decision, it was a 6-3 decision to uphold the Mississippi law. And the Mississippi law banned abortions after 15 weeks. All right. So that was that decision. That was a 6-3 decision. And of course, the conservative justices voted on what could be considered political lines. Now, they would argue that it's not politics, but, their politics do shine through. Okay. The vote was 6-3 to uphold Mississippi's law banning most abortions after 15 weeks. All right. But then it came into question this whole issue of Roe versus Wade. All right. And the decision there was 5-4. All right. And the reason was that Chief Justice Roberts sided with the liberals on the court. All right. And that he did not feel that Roe versus Wade should be overturned. All right. So the court again looked at the Mississippi law, which triggered, or helped trigger this whole conversation about Roe versus Wade. So it was a 6-3 decision along political lines for the Mississippi law banning abortions after 15 weeks. But then the question of Roe versus Wade was also intertwined within that decision. And then again, as I mentioned, Chief Justice Roberts did not join his conservative colleagues in overturning Roe versus Wade. He said that he thinks that they should have taken a more measured course. All right. And so in that particular instance, Roe versus Wade was decided 5-4, with Chief Justice Roberts siding with Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan. All right. So again, what's really important is to understand why the Supreme Court ruled the way that it did. The first thing we need to do, though, is we need to go back and mention the 14th Amendment. All right. Now, in my previous podcast, you hear me talk about the 14th Amendment a lot, because the 14th Amendment is that so important amendment that came after the Civil War. Okay. And again, you've heard me mention that this particular amendment is the amendment that has due process and equal protection, but then also settled the conversation on what to do with African Americans that had previously been slaves. All right. Remember, once they were free, what were they? So you freed somebody, but again, before they were freed, they did not have a political status. They were property. Slaves were property. And then those people that were not slaves, that happened to be African American, they still at the federal level did not have a political status. Okay. Were they United States citizens? Did they have equal protection under the law as all citizens or as white citizens in the United States? So the 14th Amendment is so important as it relates to Roe versus Wade. Okay. Because it has that due process part of it. All right. And so we know in Section 1 of the 14th Amendment, it talks about all persons born or naturalized in the United States, okay, and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, okay. So again, that specifically was to announce to the United States, the people, that African American people that are born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Okay. So again, it put to rest the whole issue of what do we do with 4 million African people, African American people that are in the United States? What political status does they have? So the 14th Amendment put that to rest, that they are citizens, okay, and subject to the jurisdiction of as citizens of the United States and the state wherein they reside. All right, so now it comes to this next part, which also, okay, was for the protection of these newly politically established slaves, but now has been used and expanded, not just for that in that time, 1868, but for future cases. All right. So then it goes on to say, no state shall make or enforce any law which shall abridge the privileges of or immunities of citizens of the United States. All right. So again, it says no state shall make or enforce any law which shall abridge. So all of the privileges, okay, that are guaranteed to citizens in Illinois should be granted to citizens in Alabama. So in essence, what the 14th Amendment did is it made all of the amendments prior to it applicable not only at the federal level, but also to the states. Okay, it's important to know that. Remember, the United States Constitution applied at the federal level. States can have their own constitutions, okay, and make their own laws, all right? But so by incorporating the 14th Amendment, it just lets all states know that no state shall, that everyone, okay, has to be treated equally. All right. So now we go into the due process and the equal protection portions of the 14th Amendment. And this is the part that will apply to Roe versus Wade, or to why the United States Supreme Court in its recent gathering decided to overturn it. Okay. Now this part says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. All right. So that's what the 14th Amendment says. All right. So now, as I've mentioned, the Supreme Court just overturned one of the most famous and controversial rulings in modern history. Okay. All right. So the majority of the court ruled that Roe versus Wade and another case, Planned Parenthood versus Casey, were wrongly decided. Of course, with their decision, which we kind of knew about a month ago because it was leaked. It's a political earthquake, okay? And it is one that will reverberate for months and years to come, reshaping American lives in ways that are easy and not so easy to predict. All right. So now, according to the Supreme Court, there is no constitutional right to abortion at the federal level. Okay. Now, yes, there is no federal constitutional right to abortion, but there is a right to an abortion in Illinois, in Colorado. All right. So some states do allow it. Okay. So in essence, what this did was it reversed the decision from 1973 and gave this decision to either have abortions or not back to the states. Okay. So I think, first of all, we need to get rid of the misnomer that all abortions have been banned. That is not true. What is true is that each state gets to decide whether or not it wants to have abortion. All right. Okay. So again, now according to the Supreme Court, there is no United States constitutional right to abortion. All right. Now, over the protest of Chief Justice John Roberts, as I mentioned, who voted to uphold Mississippi's 15-week abortion ban, but not to overturn Roe, the status quo of the past 49 years is gone. Okay. So again, this brings into light this whole question about precedent and stare decisis, which I will get to in just a moment. All right. So now, with this overturning of Roe, that shift caused an immediate change in Americans' lives. Okay. So, by the decision was actually released on Friday. So by 11 o'clock Eastern time on Friday, abortion was almost completely illegal in at least 4 states just then. Okay. So by the end of July, it will be almost completely illegal in at least another 9. Okay. And the fight over how far abortion rights should stretch or shrink will flare up in many states, surely shaping some of the most important races coming up in the midterm elections. All right. So now let's talk about what the ruling said. Okay. And then the decision for it. All right. At its heart, Roe versus Wade was about how much states could restrict abortion. In that ruling, states were prohibited from banning abortion in the first trimester of pregnancy, and their ability to regulate abortion was limited during the second trimester. Okay? All right, that structure changed. So let's go back. So, it usually takes 9 months. Okay? So we're talking about first 3 months. Okay? Prohibited states from banning abortion. Okay? And then regulated their ability, or the ability to regulate abortion was limited during the second trimester. All right. Then, that's 6-month period. Okay. All right. So now that did change. That structure changed with Planned Parenthood versus Casey, a Supreme Court case decided in 1992, which replaced the trimester framework with a single dividing line. And that was fetal viability. Okay, fetal viability. Can the fetus live on its own within a mother's womb? Okay. Now, even with that change, Americans had a constitutional right to abortion up to a certain point in pregnancy for almost 50 years. All right. So now let's hear what in the majority opinion, what Justice Samuel Alito, who was a Republican appointee, said. He explained that this right simply never existed. He says abortion presents a profound moral question. He wrote, "The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe," he wrote, "wasn't simply wrong. It was so wrong as to amount to an abuse of judicial authority." All right. We'll talk about a little bit more why he says that. But so you have to understand that this week's ruling, officially known as Dobbs versus Jackson Women's Health, relied heavily on a historical view of abortion rights. Alito argued that that approach is crucial for understanding why abortion couldn't be constitutionally protected. He says, until the latter part of the 20th century, such a right was entirely unknown in American law. He wrote, "Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy." Now, some people will debate his, historical accuracy. All right. But he acknowledged that a major precedent was being overturned. This is Samuel Alito. He's the one that wrote for the majority. But he argued that it had to be done because the justices who decided Casey actually made a mistake by relying too heavily on precedent. The court is not required to uphold a previous ruling simply because it's already on the books, he wrote. In fact, the Constitution and the rule of law demand that the question of abortion be returned to the states. Now, of course, you know that this decision is unlikely, and Alito addresses that. He says, "We cannot exceed the scope of our authority under the Constitution, and we cannot allow our decisions to be affected by any extraneous influences such as concern about the public's reaction to our work." That was another place, he argued, where the justice who decided Casey got it wrong. In that ruling, the majority explicitly noted that overturning Roe would be politically seismic and could undermine the court's authority. All right. Most Supreme Court decisions rule on the case at hand while also dropping hints about how the Supreme Court might rule on the same topic in the future. So this one was no different. In his majority opinion, again, Alito included several caveats about what the ruling in Dobbs could mean for other precedents that relied on the same judicial framework as Roe. But concurring opinions by Justice Clarence Thomas and Brett Kavanaugh suggest that there could be some disagreement among the conservative justices about what should happen next. All right. So if we look at what Kavanaugh says, for his part, he took pains to stress what the opinion did not say. The Constitution, he wrote, is neutral on the issue of abortion. All right. Roe was a mistake, he said, because it took the power to decide whether abortion should be legal from the democratically elected branches of government, but that doesn't mean it's illegal everywhere either. The court's decision today, according to Kavanaugh, does not outlaw abortion throughout the United States, he wrote. He added that just as the court doesn't have the authority to say that abortion is a constitutional right, it also doesn't have the power to declare a constitutional prohibition of abortion. He signaled, however, Kavanaugh also signaled how he at least is thinking about other legal questions that could come up in Dobbs' wake, including whether states can bar their residents from traveling to another state to obtain an abortion. And in his view, no, under the constitutional right to interstate travel. All right. Chief Justice Roberts did not want to overturn Roe. In his concurring opinion, he bemoaned the broad scope of the court's new abortion ruling. He agreed with the decision to uphold Mississippi's ban on abortion after 15 weeks, but he questioned why it was necessary to go further. The viability line, fetal viability, established in Casey was misguided, he said, but he also argued that his conservative colleagues were violating the principle of judicial restraint by overturning Roe and Casey entirely. The court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view those cases, according to Chief Justice Roberts. So in essence, what he was doing, he was asking his conservative colleagues to slow their roll. The liberal justices writing in dissent warned that the swift action in Dobbs will have serious consequences. The decision, they wrote, says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial cost. All right. So we now have the rationale behind why Justice Alito came to his decision. So we understand the background of that, the 14th Amendment, and how he says that the 14th Amendment does not grant abortion rights, and that in 1973 that the Supreme Court justices were misguided. All right. So it's important to understand that most justices agree that constitutional precedent is entitled to some respect. All right. It is an essential part of the United States legal system, necessary to create stability in the law and to enhance the credibility of the court. All right. Let's deal with that for a moment. All right. See, the reason why courts really respect precedent, all right, and are usually not willing to overturn a decision, especially one of such magnitude, is because there needs to be some stability in the country. So what if, abortion was overturned and reversed and made, again, every couple of years, There's no stability, all right? So Roe versus Wade has been in existence for 49, almost 50 years, all right? So there's been some consistency there. There's been a little bit of change with, the Casey case, which, dealt with fetal viability. And then, you have the Dobbs case in Jackson, Mississippi, which then banned abortions after 15 weeks. But still, the precedent was respected. The precedent in terms of Roe versus Wade, established law. All right. So justices also acknowledged, Supreme Court justices, that precedent is not always binding. And cases casting doubt on prior decisions have often divided the justices on ideological grounds, quite often producing 5-4 rulings, like you just saw in this one. All right. The struggle then is over the role of stare decisis. All right. It's a Latin term that embodies respect for precedent. So literally translated, it means to stand by things decided. So for discussion of precedent, it refers to standing by the rules of prior cases. All right. The debate focuses more on constitutional decisions than on those interpreting statutes. If there is dissatisfaction within the court's interpretation of a federal law, the logic goes, Congress can amend the law to correct the problem. With constitutional interpretation, however, justices feel freer to change course if they believe correction is needed, because the only alternative is amending the Constitution. All right. So at the heart of the debate is the belief by some justices that they are free to overturn past decisions they believe were wrongly decided, and the view by the dissenters that there needs to be greater justification for abandoning precedent than just a new majority changing its mind. All right. So that's where we have this fight between the Republican appointees and the liberal appointees. All right. It's really also important, to understand that the Supreme Court has ruled or overruled or reversed itself, okay, before. All right. So this is not the first time that the Supreme Court has reversed itself. All right. And so what we need to do is take a little march back in time to a case that I've talked about quite often. All right. And that case is Plessy versus Ferguson. All right. So the reason why I'm bringing this up is because I like to take that unbiased approach. All right. So we have the Supreme Court reversing Roe versus Wade, okay, which a lot of people don't like, okay, and feel as though this is judicial overreach, even though the conservative justices will say that back in 1973 that was judicial overreach. All right. But some people feel that way. Some people feel that during their confirmation hearings that Justice Brett Kavanaugh and Justice Neil Gorsuch lied, when they said that they, respect established precedent, but yet voted decided to, help in the decision overturning Roe versus Wade. All right. But if we go back in time and look at the Plessy versus Ferguson case, and that was the case from back in 1896, where it was decided that separate but equal was the law of the land, which meant that southern states, or in actuality any state, could have laws on the books that kept the races separate as long as they were equal. All right. Now, I don't know what the Supreme Court justices back then were thinking in terms of what equal meant when you had slavery just ending. OK, and how could these African Americans that have been enslaved, for hundreds of years now become so equal, with white citizens that had been in this country for a couple of hundred years, if not more. OK, how are you going to make that work? All right. But in any event, in terms of equal, so slaves now can, you can eat at the same countertop, in rural Alabama, when just years ago you were, cooking, and now you're going to sit at the same? Probably not. OK, but that's the reason why years later in 1954, almost 60 years later, that the Supreme Court reversed this whole separate but equal thing and made mockery of it by saying that, in this country, it was never separate and equal. It was separate and unequal. OK, and that was the Brown versus Board of Education decision, which clearly showed, OK, that white students were getting far more advanced educational opportunities and from first grade to high school than black students were. There was no equal access to education. All right. There was no equality there. All right. And so the Supreme Court reversed, all right, its earlier decision. All right. Now, kudos to that. Because where would people like me and others be if they had not done that? And can you imagine in the year 2022 that we're still separate but equal? So for those that argue that, this whole thing about respecting precedent has been violated, I think sometimes the Supreme Court does need to take a look back at the decisions that it made when they come before them again and say, that was a different time. Maybe we should take a look at this. Okay, that's my argument. Okay, so they did that in this particular case, Roe versus Wade. All right. So are we angry with just the decision, or are we angry that we feel as though they violated established precedent? Okay, because if we're angry because they violated established precedent, then I will have to say that I'm actually glad that the Supreme Court does go back and look at cases and say, well, you know what, maybe that court in 1896, okay, with all of its racist and ex-former slave owners on it, with the exception of one, maybe they were wrong, okay? And that 60 years later, as society has grown, and feasibly, we would like to think gotten better, that we now see that, perhaps that wasn't right, okay? Now, if there are any people that want to argue with me and say, oh, so what are you saying, that you agree with the Roe versus Wade decision? That is not what I'm saying at all. What I'm saying is that I understand that when it comes to precedent, okay, that sometimes we need to look at what we did prior in order to become better, okay? Now, I'm not saying that Roe versus Wade, that now that it has been reversed, and that it is not the law of the land. What I am saying is that now the decision is back to each of the individual states to decide for themselves. There is a remedy for this, though. Okay. There is a very easy remedy, okay? And that remedy is this, okay? For young people and for those that vote on the more liberal side, Democrats, and then for those independents, okay? And for those people that believe in a person's right to have an abortion, or a woman's right to have an abortion. So there is a midterm election coming up in November, okay? And so if this is one of those cases that has now challenged you and gotten you upset, then what I would suggest you do is register if you have not, and then in November, go and vote for those individuals that can help make abortion the law of the land, because there is a way to do this. All right. See, what the Supreme Court does is it interprets the Constitution. The Supreme Court is not supposed to make laws. So let's go back to grammar school, American government. All right. So we have three branches of government. We have an executive branch that executes or enforces the laws. We have a judicial branch which interprets the law, and we have a legislative branch that makes the laws. All right. So the justices in this case, in the case that reversed Roe versus Wade, what they're saying is that there is no law. There is no law. Okay, there is no constitutional right. There is no law for Roe versus Wade. They're saying that it was judicial overreach back in 1973. You can argue that point if you like. But the fact is, okay, and then the question actually is there a constitutional right to an abortion? Is there? Okay, so now because at the federal government, or Congress rather, could not decide on whether it wanted to take up this big issue, it left it to the Supreme Court to decide it. Okay, and so in 1973, they decided it because Congress could not or would not, okay, at some point in history, decide upon it. And it might have simply just been that they felt like this was a state issue and not a federal issue. But then when a case comes to the federal courts and it rises to the Supreme Court, then they have to interpret what it means. And so they did so, and I will say they did so admirably in 1973, and then they reversed it admirably in 2022. Okay? Following simply what they felt the law says. All right. The liberals will argue that, well, stare decisis, we should respect precedents. Okay. That we should stand by things that have been decided. Again, I make the argument that would they say the same thing, all right, about Plessy versus Ferguson. All right. So I'm just arguing just the facts, not the emotions going along with Roe versus Wade or Plessy versus Ferguson. Okay. Now, if I had to bring emotions into it again, as an African American man, I'm certainly glad in 1954 the court reversed their stupid decision in 1896 that said we should be separate but equal. Okay, because there was never equality for black people. All right, so that's my point. Now, what can Congress do? Well, if you just heard me a couple of minutes ago, Congress makes the laws, not the United States Supreme Court, not the judicial branch. All right. So all it takes is for the House of Representatives or the United States Senate to draft a bill which says, in essence, that a woman has a right to an abortion either in full or in the first trimester or in the second trimester, or however they want to complete or prepare that bill to move forward. That's all you have to do. Now, that sounds simple, just on its face, okay? But of course, there's the political realities. Right now, in the House of Representatives, it is led by the Democratic Party under House Speaker Nancy Pelosi, all right? You can get a bill, all right, in the House that states that abortion is legal, okay? The problem is the United States Senate. All right. And for those of you like me that are students of political science, there are 50 Democratic senators and 50 Republican senators. All right. And then there is a tie cast vote, which of course is made by the Vice President of the United States, which so happens to be Kamala Harris, okay, who is a Democrat because the President, Joe Biden, is a Democrat. All right, he's in office. He's the president. All right, so now it seems simple, right? Well, if you've got a majority of the House members to vote for abortion and you can get 50 plus 1, Kamala Harris, of the United States senators to vote, then guess what? We have abortion rights in this country. Wrong. Okay? It's not that simple. It could be that simple, but it's not that simple. The reason is because there is this little thing in the United States Senate called the filibuster. Okay? And what that means is simply this. All right? That you need 60 votes. Okay, you need 60 votes to bring an issue, okay, like abortion to the floor. All right. And if you can't get 60 members of the Senate to agree to that, then guess what? It's a moot cause. All right. So, yeah, you would only need 51 to make it law, but you need 60 to even bring it to the floor to discuss it. All right. So that's the problem with, wow, how do we remedy this? If we didn't have the filibuster, it could be remedied in no time. All right. So for those of you that are abortion rights folks, all it would take is an act of Congress. Okay. But then the political realities have to chime in. So I go back to there's midterm elections. All right. So if you are believers in abortion rights, then I would suggest that you vote in mass. I want to mention this too, that, even though the Supreme Court made this decision and it is unpopular. All right. Let's take a look at what the American public says. The majority of Americans said that Roe versus Wade should stand. It should be left as it is. So now let's go back to, we have midterm elections and there are a lot of people up for re-election. Okay. Knowing that these people that are anti-abortion are coming up for re-election, this is a great time for those of you that are abortion rights advocates to go to the polls. If you want there to be change, the only way there can be change at that level is to vote in the people who represent your interest. Okay, so you can't continue to sit on the sidelines. You can't be armchair quarterbacks. All right, you can't be Monday, morning, hypocrites. Okay, that want to say, well, the reason why this happened is because no, you've got to actively be engaged. All right, the reason why. All right, there are 3 members, more recent members of the United States Supreme Court, okay, is because back in 2016, not enough people took seriously Donald Trump's candidacy versus Hillary Clinton's candidacy. I mean, we're talking about a tiny majority that Donald Trump won. So if there were more people that came out in those states, okay, that went red, that usually or oftentimes don't, then we have a different outcome. So instead of Donald Trump getting the ability to appoint 3 justices to the Supreme Court, that would have been Hillary Clinton. And so now we would have a different social stratus when we look at how courts make decisions, at least at the Supreme Court level, and then even trickling down into the courts of appeals and the district courts. All right, things could look totally different, but again, it's because there was a lack of voter interest and people taking for granted. So now I hope that people will stop taking elections for granted and get out and start voting, because this is really important. All right. So what we have in this particular case, and again, this is for people that are abortion rights advocates. Now what you have is a Supreme Court that has made these decisions, or at least this decision that goes against what you feel is right. But now there's this opportunity to look at other decisions. And now that they have set the precedent, in a sense, okay, that they will overturn a precedent. All right. Well, it begs the question, what else could be reversed? All right. How about contraception? Is that a right guaranteed in the United States Constitution? No, it doesn't say it. All right. What about gay marriage? All right. Well, does it say in the Constitution, all right, that you have a right to marry someone of the same sex? All right. The issue could be debated with, well, it doesn't say in the Constitution, all right, that you have a right to marry someone that is of a different race. Well, it may not say that, all right? But remember, this country was supposed to be founded based upon the equality, the right to life, liberty, and property and happiness and all of those things, all right? And so we fought a civil war that determined, all right, that we were to be equal racially, all right? This is the key. I want you all to understand. And then there were civil rights acts that went into place, all right, that guaranteed that we were to be treated equally racially, all right. But then also there was a Supreme Court decision, Loving versus Virginia, that established that, these are rights that are implied in the United States Constitution, backed up by the 14th Amendment, civil rights laws, and just common decency. All right. Then not to mention we fought a civil war, over slavery. All right. And whether or not we are all to be equal. And then don't forget the 14th Amendment, which has an equal protection clause. All right. And remember again, that equal protection, that 14th Amendment originally was written, to ensure that African Americans, okay, had equality throughout the land. Okay. And so that's the argument for, does it apply to interracial marriage? Not. But what about gay marriage? Okay. See, that's different. All right. And even though gay marriage is now precedent, okay, it is the law of the land, it can easily be reversed just like for the same reasons that Roe versus Wade was reversed. All right. And if I'm not mistaken, Justice Clarence Thomas has even mentioned that maybe that's something, if it comes before the court, for us to take a look at. But again, that's why Congress has to act. All right. We continue to vote in these ultra old baby boomers, okay, who came from a time where, there was separate and unequal. All right. Some of them, have social mores and social and ethics that are different than younger people. Many of them may not have the same respect for diversity that younger people do. Not all cases, and I'm just generalizing, not everyone, of course, okay? But the fact of the matter is, some of these people are just too freaking old to be in office, okay? And it's time for new ideas and new directions, all right? And so, again, we have a Congress that has an established role to make the laws. And we have an executive branch whose role is to enforce the law. So right there, we have two branches of government that can mitigate the Supreme Court in terms of their decision making as it relates to interpreting the Constitution. All right. All Congress has to do is act. Now, of course, the law can be challenged and it can be looked at by the Supreme Court. All right. But it doesn't take much. I mean, think about all of the laws that are written and established by, Congress. And how many of them come to the Supreme Court? How many of them are decided at the federal courts or at the Court of Appeals? Not as many. Okay. All right. Especially if the public sentiment is certainly for that. So, for example, if the Supreme Court decided, hey, maybe we want to reverse, if we could, but they couldn't, reverse interracial marriage. Do you know how many people? First of all, Clarence Thomas is married to a white woman, okay? And Justice Barrett has 2 black kids, okay? All right. So there's 2 votes right there that's not going to go for it, all right? So we live in a totally different social time, all right? And so while you have a lot of people that understand, all right, that interracial marriage is just something that is within. We're supposed to be a melting pot anyway. But there's still a lot of people that would disagree on gay marriage. Okay? All right. So that's why there needs to be an influx of younger people, more youthful people with better ideas, newer ideas that are in the United States Congress, the House of Representatives or the Senate. How old is Mitch McConnell? Okay. I'm talking on both sides. Joe Biden is in his 80s. So we can't find people in their 40s and 50s to become president. I'm just making an observation. How old is Nancy Pelosi, the House Speaker? So we have all of these individuals that are running the country, making laws, making decisions, and many of them are really, really old. All right. So that's just something we need to think about, too, as a country. But anyway, I just wanted to talk to you all today about the Supreme Court and Roe versus Wade and why they made the decision. And just to provide you with a little bit of perspective on why this decision was made. All right. So anyway, listen, I don't want you to forget. Please check out my website at www.jadenmiller.com. You can find all kinds of interesting information. There's my bio there. You'll find that my wife and I also are photographers. We do mostly weddings, but we'll do other events as well. All right. You'll also be able to find the link to my podcast, Think About It with Jaden Miller. All right. And then also you can find me on my YouTube channel. Please like, share, and subscribe. And it's Think About It with Jaden Miller on YouTube. And then, of course, I'm on all of your favorite podcast platforms: Spotify, Apple Podcasts, Spreaker, Google Podcasts, Castbox, iHeartRadio, Audrey, Podvine, Amazon Podcast, and many, many more. All right. So again, thank you for joining me for this episode of Think About It with Jaden Miller. I look forward to your comments and your thoughts. And listen, continue to have a really, really great summer, because I am. Have a great day.
Thank you for listening to Think About It with Jaden Miller. Don't forget to like and subscribe to his YouTube channel, and like and follow on your favorite podcast platform.